Once more, by popular demand, we will again revisit Texas Senate Bill 140, which became effective September 1st, 2025, and amends the Texas Deceptive Trade Practices Act to make certain types of unwanted spam text messages potentially actionable and recoverable under Texas and federal law. My name is Chad Cummings, and I am a Texas attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at the university level and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. If you live in Texas and your phone has been blowing up with spam text messages, be they promotions, sales, offers, or other solicitations that you never asked to receive, you may now have a powerful legal remedy. As of September 1st, 2025, a new Texas law called Senate Bill 140 gives people like you real teeth to fight back against businesses that send unauthorized and unwanted commercial text messages. For years, spam messages were more of an annoyance than a legal issue. But with the enactment of Senate Bill 140, that changes. If a company sent you one or more promotional texts without your explicit written permission on or after September 1st, 2025, they may now owe you real money, and you can make them pay by working with a licensed Texas attorney. This is not just about shady offshore scams or generic robocalls. Senate Bill 140 applies to actual businesses operating in the United States, even local ones here in Texas, if they use text messaging to market goods or services to Texas residents. That includes, for example, restaurants offering discounts, gyms pushing signups, car dealerships announcing specials, and really any business using text messages to get your attention without your informed prior consent. Under the new law, these businesses are now required to follow strict rules when texting Texas residents, and violations carry significant consequences. To understand how the law works, you first need to know what kind of messages are covered. Senate Bill 140 targets so-called telephone solicitations, and for the first time, that legal definition now includes commercial text messages. If the message promotes a business, product, or service and lands in your text message inbox without your prior express written consent, it likely qualifies as an actionable violation. It does not matter whether you clicked on the link in the text message. It does not matter whether you deleted it, although certainly we would like you to maintain screenshots for use if we choose to work together in pursuing a claim. If you never opted in, or if you tried to opt out and they continue texting you, that business may have broken the law. The law also sets rules around when businesses are permitted to send text messages. They are banned from sending messages before 9 a.m. or after 9 p.m. local time. If you received a message in the middle of the night or early in the morning, that alone could be an actionable violation. And on Sundays or official Texas holidays, any commercial texts are completely prohibited. The time of day is measured based upon when you, the recipient, actually received the message, not when the company sent it. This means they cannot use technical delays or server time zones as an excuse. Another critical protection involves your right to opt out. If you texted stop or unsubscribe or otherwise communicated to the business to stop contacting you, they are required to immediately honor that request without delay. There is no "will remove you soon" disclaimer. If they keep sending messages after your opt-out, the law considers that to be a serious violation. And if they sent multiple texts after your opt-out request, each message could potentially count as a separate offense. Under Texas Senate Bill 140, you can sue the businesses in court and recover money damages in certain cases. For each violation, you may be entitled to up to $1,500 or even more if the business acted knowingly or willfully, which often includes situations where you clearly opted out and they continued to text you anyway. Even if the violation was not willful, there are damages available under the Federal Telephone Consumer Protection Act, or TCPA, which still applies in most cases and operates alongside of and not in place of Texas Senate Bill 140. And unlike many consumer protection laws, Texas Senate Bill 140 includes mandatory attorney's fees. That means if you win, even just a single violation, the business must pay the fees of your attorney on top of your damages. This dramatically shifts the power away from big companies and gives everyday Texans a way to hold them accountable. So, what counts as written consent? It must be real, traceable permission, something you actually gave in writing, not just by merely using a service or accessing a website. Businesses must prove that you gave them real permission to send marketing texts, and vague references in a boilerplate privacy policy or sign-up form will not cut it. They must have records showing you specifically agreed to receive specific promotional texts. If they cannot produce that evidence, the law presumes the messages were unauthorized and therefore potentially actionable. Another key provision of Texas Senate Bill 140 ties into the Texas Deceptive Trade Practices Act, or DTPA. When a business sends unlawful texts, it is treated as engaging in deceptive or unfair trade practices. That opens the door to even more remedies in your favor, potentially including triple damages, or what attorneys call treble damages, and injunctions. The law is designed to punish and deter businesses that ignore consumer rights and push aggressive or misleading promotions via text message. Importantly, you do not have to have suffered monetary loss or physical harm to have standing to sue. The law recognizes the invasion of privacy and annoyance caused by these messages as a legitimate harm under Texas law, and you can recover money potentially for each individual violation. If a company sent you 10 messages and you never gave your written consent, your claim could potentially be worth thousands of dollars, especially if you opted out and they continued sending you those messages, though I must emphasize that every case is different. Now, what if you are on the national or Texas do not call or do not contact list? That gives you even more protection. If your number is listed and you still received unsolicited and unwanted marketing texts, the law assumes that those messages were unauthorized. The burden falls on the business to prove otherwise. Being on a do not call or do not contact list does not prevent you from consenting later, but if you never gave your explicit written permission, your inclusion on the do not call or do not contact list further helps to establish your case. Texas Senate Bill 140 does not apply exclusively to SMS or text messages because it is what attorneys call technology agnostic. This means if you received an iMessage, WhatsApp message, Facebook message, direct message on X or Twitter, or Instagram message on your mobile device instead of a standard SMS or MMS text message to your phone number, you may still potentially be entitled to compensation under the new law. The law specifically targets telephone numbers and the cellular networks used for text messaging. Therefore, if those messages were routed to your mobile device or used your SMS inbox via a mobile application, they may still qualify depending upon how they were delivered. Similarly, spam emails are not covered by this particular law, at least not directly, but they may still violate other statutes, including the Federal Can-Spam Act. If you wish to enforce your rights, the first step is to preserve evidence. Take screenshots of text messages and ideally do not delete them. Save the dates and times. If you opted out, document how and when you did so. Keep a record of the business name, the phone number they utilized, and any links or calls to action in the message. If you received dozens or hundreds of messages, a spreadsheet or log can help you organize them. The more detailed your documentation, the stronger your potential case may be. Next, you may wish to contact a law firm that handles Texas Senate Bill 140 claims on a contingency basis. That means that the attorney only gets paid if they recover money for you. Most firms will first send a formal demand letter to the business and attempt to negotiate a settlement. If the business fails to respond or refuses to settle, your attorney can then proceed to file a lawsuit. On a contingency basis, you do not need to pay anything upfront to pursue a claim in most cases. In summary, Texas Senate Bill 140 provides Texas residents powerful new rights to stop unwanted text messages and hold violators accountable. You do not have to tolerate spam text messages anymore. If you are receiving promotional text messages for which you never consented, especially after opting out, you may be entitled to significant compensation. The law is on your side. Now it is up to you to use it. Again, my name is Chad Cummings, and I hope you found the information in this presentation helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.